Guy was rear-ended by a teenager driving his mom's car, but he doesn't have insurance, and the mom says that she didn't give him permission to take the car and isn't going to pay. What should I do? That's a very valid question.
Yeah, you know, the good thing is whether the son had insurance or not, the mom most likely had insurance on the car. The fact that she may have not given him consent is kind of a cause for concern, and I'll come back to that. The first thing that kind of stands out to me is the issue of it being a teenager. Now, it doesn't really specify whether it's actually a minor versus just a teenager. If it's a minor, even if the minor didn't have consent to operate the vehicle, when you go in to get a driver's license, if you're under the age of 18 in Florida, you have to have an adult that's willing to sign off on the driver's license application and agree that if you're involved in an accident, that's your fault, that they'll be financially responsible for any damages that you cause. So, you know, without getting into the issue of whether there was consent or not, that would be the first thing you would look at, is who might have signed their driver's license application if they're a minor. And if it was the mom, regardless of whether she gave her permission to drive the vehicle, she's still going to be responsible. If it was the father or an aunt, whoever that is. The second thing that would come into play is perhaps there was some negligence on the mom's part. You know, the son takes the vehicle. She says she didn't give him consent, but she didn't actually do anything to try and prevent him from taking the vehicle. If that were the case, if there was some negligence on her part, she knows he does these kinds of things from time to time, but she doesn't take any precautions to prevent him from taking the vehicle. It could be negligence for not securing the vehicle. It could also be that, you know, she actually did consent, but it was more of an acquiescence rather than actual verbal consent. In Florida, we have what's called the dangerous instrumentality law, which makes someone, the owner of a vehicle, responsible for any damage that's caused by that vehicle. One of the caveats is, though, that it has to be, they've got to loan the vehicle to someone with their permission. That doesn't have to be express permission. It doesn't have to be the mom saying, you know, the son coming in and mom asking mom specifically, hey, can I take the car to the store? If there's a pattern, you know, the vehicle's always available to him, he's supposed to ask, but he doesn't in this particular instance. She's still going to be held responsible under the dangerous instrumentality doctrine. Normally that's a fact question. The types of things that would actually negate consent and liability under the dangerous instrumentality doctrine are basically crimes. You know, not only did he take it without her consent, it was a wrongful taking. It wasn't something that he just didn't ask permission from mom to go to the store. It's the kind of thing where a lot of times we're asking, well, did you call and report it to the police? Because if you didn't call it and report it to the police, was it really without your consent?